What's up, y'all? This is your boy, the non-lawyer, coming back again with yet another video on this whole fiasco with Cardi B and Tasha K. So I've been watching a couple of videos that were made by other creators, and one of the things that's come up is that people are talking about how Tasha K can file bankruptcy and then try to discharge the debt from Cardi B from the Cardi B case, discharge it, which essentially means you're just going to get rid of it, right? And I've heard a couple of people go back and forth on this, essentially saying that she can't discharge it, right? And we're going to get into that in a minute here. And that got me to thinking, how could Tasha K get rid of this debt? And I actually found a way that Tasha K could actually use, or a technique that she can use to reduce the debt. And it's kind of like a little known dirty little secret that a lot of people overlook. I know that Tasha K allegedly, right? Well, not allegedly. If you go to Tasha K's channel and you look at the video where she addresses this whole case, again, she calls it a conspiracy. Everybody and their damn mama know it's not a conspiracy, and there's no system out to get her, right? But she calls it a conspiracy. But in that video, she says that she's going to appeal. She says the appeal is already on the way. Now, of course, an appeal is one route to go about it, but there's actually another little technique, or maybe technique is the wrong word to use, but there's another path. There's another path. Now, this path doesn't eliminate her chances of appeal. It just gives her one little extra option for trying to reduce this debt, right? So, because let's be honest, once she goes to appeal this judgment, more than likely what's going to happen is that the best possible outcome is that she'll just get it reduced. That's the best possible outcome. Reduced, or she'll probably have a new trial. And to be honest with you, a new trial is not, in my personal opinion, is not going to help her, right? Unless she does it a certain way. I don't want to spoil too much. I don't want to give you too much because I don't really want to spoil what I'm actually going to get into in a second here. But she's appealing the judgment. And, people are even saying that, that's a waste of time. But I think that she's appealing the judgment because she wants to monetize that entire appeals process. Because the other thing she says on the channel is that she's going to keep people informed every step of the way of the appeal. She's monetizing that, right? She wants to create content where she'll have something to talk about during that whole appeals process, and that in and of itself is going to generate more income for her. So that's a technique that I think she's actually using to help make money off this whole thing, right? But again, I have found a way that a path that she can take that's going to allow her to reduce that judgment, right? Allow her to reduce that judgment to something reasonable, right? And we're going to get into that in a second. But first, let's talk about this possibility of filing a bankruptcy, right? So on someone's channel, I was watching them talk about the bankruptcy, and what happened is that they were talking about filing a Chapter 11. And in a Chapter 11, I'm actually on the United States government's website here. This is a United States court, and it talks about the basics of a Chapter 11. So this information I'm giving to you is an official source. So one of the things they have here is an adversary proceedings, right? And you may ask yourself, what is an adversarial proceeding or adversary proceeding, right? So I have right before me, what page I'm on, because I don't want to miss my page. I don't want to forget where I am. I am on page 79, but right now what I'm reading is the Federal Rules of bankruptcy procedure. So this information that I'm giving you is from an official source. You know how the non-lawyer is. He's not finna just make up something and give you garbage. Everything that I give you, I'll let you know when it's just my own personal opinion, but I try to come with the facts, right? I try to come with the facts and correct information. And you guys, you can decide yourselves whether or not the stuff I'm giving you is true and correct, or if it's legit information. You decide, right? You tell me, right? All I can do is read stuff to you. I'm not a lawyer. I'm not running back and forth to court, filing motions. Well, actually, I am, but I don't do this for a living, right? So I can only read stuff and I can only let you be the judge, right? So if I can get back to page 79, they talk about an adversary proceeding, and then they give you essentially the definition of an adversary proceeding. And I'm just going to go ahead and sum all this up. You can read this if you want to. Federal Rules of Bankruptcy Procedure, page 79, and it's going to be Rules 7001, Scope and Rules, Part 7, Part 7, Adversary Proceedings, right? So I'm summing this up. So an adversary proceeding is a process whereby a creditor or a debtor can challenge debt, right? Establish or challenge debt. That's my summary, right? However, if you look at item 6, it says a proceeding to determine the dischargeability of a debt. So that means, or for the purpose of this conversation, we're talking about filing a bankruptcy, having Tasha K file a bankruptcy so that she can discharge a debt, right? She wants to discharge that $3.8 million, or at least some of it, right? Now, here's the thing. I think in the conversation on the other creators channel, they were saying, well, hey, if you file this, there's going to be a chance that you're going to be sanctioned, right? There's going to be a chance that you'll be sanctioned. And that leaves us with making a decision on whether or not you actually want to file this. Now, actually, I was on the section for sanctions. I'll have to do a page search to find it again, because they talk about sanctions in this thing. Yeah, so Rule 99011, right? Signing of papers, presentation to court, sanctions, verification, and copies of papers. And by the way, guys, if you can't see this stuff, I'm going to enlarge it a little bit, but if you can't see this stuff, you want to go to your settings and you want to try to enlarge the fonts, and you should be able to see this stuff a little bit better. So anyway, we finna go over to page 121. So if we go over to page 121, I'm not even seeing, okay, 93, 101, 107. Come on, come on, come on, come on, come on, come on. 121. Bam. All right. Signing of papers, presentations to the court, sanctions, verifications, and copies of papers, right? So if we go down a little bit here, it talks about sanctions, right? So it basically goes, and I'm just going to read this stuff to you verbatim, right? If after notice of a reasonable opportunity to respond, the court determines that subdivision B has been violated, the court may subject the conditions stated below, impose an appropriate sanction upon the attorneys, law firms, or parties that have violated subdivision B or are responsible for the violation. What the hell is subdivision B? Representations to the court. Okay, so this is subdivision B, right? By presenting to the court, whether by signing, filing, submitting, or later advocating a petition, pleading, written motion, or other papers, an attorney or unrepresented party is certifying that to the best of the person's knowledge, information, and belief formed after an inquiry, reasonable under the circumstances, so on and so forth. Essentially, you're basically signing the document, and you're signing the document in good faith. And I mean, I can read all this stuff to you, but you're signing the document under good faith, and you're saying everything is true, and you're not trying to pull a fast one, right? But let me read some of the stuff to you. I hate reading because a lot of times I'm just going to bore you to death. But you're signing this document, and you're saying it is not being represented for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in cost of litigation, right? The claims, defense, and other legal contentions therein are warranted by existing law, right? Or by non-frivolous arguments for the extension, modification, reversal of existing law, or the establishment of new law. And actually, this is pretty important because I'm glad I read this. I'm really glad I read this. I'm going to read it again. The claims, defense, and other legal contentions therein are warranted by existing law or by non-frivolous arguments for the extension, modification, or reversal of existing law or establishment of new law. And actually, this actually puts a totally different spin on the video I was actually prepared to give to you, because essentially you have the law and the law is well established. However, just because the law exists and it's well established, be it statute or maybe common law that has been established over centuries of time, just because those things exist, it doesn't mean you can't make a new argument to overturn the pre-existing law, right? So this actually totally changes what I was about to say, right? Because I think on the other creators channel, they were talking about sanctions and what would happen if you filed a adversary proceeding to discharge debt, whereas the law says that. Oh, and I left this piece out. So th- what what they were saying is that certain debt can't be discharged, right? And we're going to get into that. Let me just finish reading all this, right? And then it goes, the allegation and other factual contentions have evidentiary support, or if especially so identified, are likely to have evidentiary support after reasonable opportunity for further investigation or discovery. And the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on the lack of information or belief, right? And then it gets to the sanctions part that I read, right? So I think I'm jumbling this whole thing up here, so I may have messed it up. So let's take a step back. So the bankruptcy proceedings has this option for adversary proceedings. In adversary proceedings, you can actually discharge debt. And the way I imagine this will work, because I've never done it, right? And I don't know anyone who's done it, but the way this works, I imagine, is that you go to bankruptcy court and there's debt that you want to get rid of. And what you would do is you would file an adversary proceeding, right? Challenging this actual debt. And if that person doesn't show up, if that creditor doesn't show up, then the court probably wouldn't have any choice to discharge the debt, because they're going to have to take everything that you said, or everything that you said in your motion, as fact, as true, because there's no one there to challenge it. So this was what essentially was mentioned on the other creators channel. There was a couple of lawyers going back and forth. So if you file the adversary proceeding and the other party, the creditor, doesn't show up, bam, they discharge his debt, the debt is gone, right? However, if Cardi B does show up, so let's say Tasha K goes in, she files this, and she said she puts in the wording to actually challenge that. I'm going to escape the wording right now because I'm not 100% sure on the wording of the actual verdict. So all we would say is that you would have to put some legitimate wording, whereas you have a reasonable chance to have this debt discharged, right? However, another lawyer on that same creators channel said you can't discharge certain debts, right? So here I am on United States Bankruptcy Code.org. I don't know if this is a government website. I think it may not be, but it talks about section 523, and it says exceptions to discharge, right? So there's certain debts that you can't discharge, right? So if we scroll down, it says for willful and malicious injury by the debtor to another entity or property of another entity, right? So if you willfully, maliciously cause harm to somebody and there was a judgment awarded against you, that debt, according to this statute, could not be discharged. However, however, let us not forget what we just read. We just read that although there is pre-existing law and although there is pre-existing common law, that in and of itself is not does not stop you from making a good faith argument on overturning statutes and pre-existing law. So in other words, if Cardi B's lawyer can come up with a good faith argument on why these pre-existing statutes, right? This what is this 523, what is this? 523C6, right? So if Cardi B's lawyer can come up with a good faith, reasonable argument of why 523C6 shouldn't apply, then yes, she can go and she can file that adversary proceeding. Plain and simple. Am I reading this right? Is my logic off? Is it not clear? Right? However, you have to consider what would potentially happen if you just go in on some bullshit and you just file this just to be filing it, right? So it says basically by motion, a motion for sanctions under this rule shall be made separately from other motions to request and shall describe the specific conduct alleged to violate subsection B, what we just read here, right? Misrepresentations to the court. You're misrepresenting, you're making a misrepresentation to the court. It shall be served as provided in Rules 7004. The motion for sanctions may not be filed with or presented to the court unless within 20 days after service, the motion or such other period as the court may prescribe. The challenge paper, claim, defense, contention, allegation of now is not withdrawn or appropriately corrected. So long story dull, in order to catch Cardi B, I'm sorry, in order to catch Tasha K and her lawyers from filing a frivolous adversary proceedings, they have to file a motion and explain why the adversary proceeding is frivolous. So here's the thing with all this. Here is the thing, right? I know this video is a little bit heavy with all the reading, but we just read number one, just to recap, we just read number one that you have the ability to discharge debt or challenge any debt in the bankruptcy proceeding by filing an adversary proceeding. Creditors have the ability to start an adversary proceeding, and you yourself as a debtor have the ability to get rid of any debt by filing an adversary proceeding. So if Tasha K files this, Cardi B don't show up, bam, that debt is gone, right? But if Tasha K files this, Cardi B shows up, then what could possibly happen is that Cardi B can file for sanctions and say, hey, look, she knew this debt wasn't supposed to be filed as a discharge, and I had to pay all my lawyers to come down here and deal with all this bullshit, and this is costing me more and more money. I want to get my lawyers' fees in this. I want to get additional fees for harassment, so on and so forth. I want to crucify this bitch. So then they would file a motion for that, and then basically the judge would make a decision on whether or not there would be sanctions. But here's the thing. Let's think about this. If if Tasha K's lawyer can come up with a really good faith, good enough reason, right, to essentially file an adversary proceeding to discharge the debt, right, then they need to go ahead and file it. Because if they have a good faith argument, meaning they're not on any bullshit, they studied the law and they came up with a very good reason on why the debt has to be discharged, then in that scenario, they can't. The Cardi B's lawyer can't file sanctions because they came up with a good faith argument. Now, again, what's going to be a good faith argument? I really don't know because I haven't really been paying attention to the actual judgment. And I paid attention to the case in the beginning, but the final judgment I really didn't pay that much attention to it. I'm starting to get caught up on all this now, so I don't know what could be a good faith argument. You would have to do Tasha K's lawyer would have to do a lot of research and digging and to see if they can come up with something to warrant going into court, bankruptcy court, and filing an adversary proceeding to try to get rid of that stuff, right? So another possibility is that they file this thing, and then Cardi B actually shows up, and just because she shows up doesn't necessarily means that the debt is going to stay, right? Cardi B could show up and fight, and Tasha K could still win because her lawyers did research. She probably have to get rid of Olga because everybody keeps saying Olga is a horrible attorney. I know for one thing what they're saying is that she actually does criminal, not civil. So she'll probably have to find a really good bankruptcy attorney and to actually do this. You don't want to go with any blow Joe. You want to go with somebody that does this all day, every day, and they can come in with some level of mastery to to, to actually do this for you, right? So she needs to find a really good bankruptcy attorney. So let's say she finds that bankruptcy attorney. He goes in, he files adversary proceeding. He gives a really good reason for overturning section 523C6 or whatever it was. Cardi B shows up in that adversary proceeding, and at that point, she has to fight. She has to file a motion to basically defend that debt, right? She has to file a motion to defend that debt, right? Uh, on the flip side, if the motion is frivolous, then of course Cardi B is going to go for the legal fees, right? But you have to put all that into context, because if if Cardi B gets the legal fees, what is that going to be? You know, what's a reasonable sanction at that point? What, an extra $20,000 or $30,000 for legal fees? So now you have to basically do the math. You have to do a cost benefit analysis. You have a chance to wipe out $3.8 million in debt. And all you got to do is risk being hit with another $30,000 in debt. This is nothing to think about for me. I'm sorry. I'm filing that shit. I'm filing it. I'm going to do the research, find a legitimate, good faith argument on why that debt should be discharged, and I'm filing it. Fuck the dumb shit. I'm filing it. Because the worst that's going to happen is that you're just going to be hit with additional legal fees, and it's not going to be another million. And hell, even if it is going to be another a million, I'm still going to take that chance because I got a chance of getting rid of 3.8 million. But in all reality, it's probably going to, because it's not going to be a long drawn out proceeding. At least I hope it wouldn't. I don't know, right? But you have to do a cost benefit analysis. So you have to figure out how much it would cost Cardi B to come in and defend that, and then you take that number, which I'm just going to assume, I'm just going to throw it out there and say it's no more than $30,000, and then you look at the benefit. The benefit is you're going to eliminate $3.8 million in debt, right? And the risk is that you just get hit with another $30,000, right? I'm sorry. Fuck what you heard. I'm filing it. I'm filing the adversary proceeding in bankruptcy to discharge that shit. I'm sorry. But anyway, the funny thing is, that's not even what I actually made this video for. What I made this video for is that there's other options, right? There's other options out there. There is a way that Tasha K can actually reduce the debt.